I want to begin by thanking David for his work. He's developing a history-based theory on American citizenship, and the historical foundation for that theory, as I understand it, is going to be in Chapter 2, which is still in process. So rather than critique the theory, I'm going to focus my comments on some of his historical claims in Chapters 1, 3, and 4, and pick out the two that I especially disagree with, and then we'll have a conversation. The key provision for David's theory of the rights of national citizenship, of course, is the Privileges or Immunities Clause of Section 1 of the 14th Amendment. And like many historians before him, he looks at that clause through the lens of the Civil Rights Act of 1866. And there are many reasons why this association seems to make sense. Both the Act and the Privileges or Immunities Clause were passed by the same Congress at about the same time, and they both limit their protections to United States citizens. But when you take a close look at the Act, some problems appear that actually call into question, I think, the relation between the Privileges or Immunities Clause and the Civil Rights Act. To begin with, the Civil Rights Act, as originally drafted, extended its non-discrimination protections to all persons, regardless of citizenship. And we also know that after the ratification of the 14th Amendment, Congress repasses the Civil Rights Act, and again, with the exception of the real estate provisions, extended its non-discrimination protections to all persons, regardless of citizenship. And so that seems to suggest that the non-discrimination principle underlying the Civil Rights Act was not particularly associated with the status of citizenship. Another problem with trying to view the Privileges or Immunities Clause through the lens of the Civil Rights Act is that when the clause was presented to Congress, no one claimed that this particular provision in Section 1 protected the rights of the Civil Rights Act. And in fact, some seem to suggest that it was the due process or equal protection clauses that would empower Congress to pass anti-discrimination provisions like the Civil Rights Act. Now, to his credit, David acknowledges that no framer explicitly linked the clause to the Act, but he suggests that their failure to do so was driven by fear. According to David, if they openly admitted that the clause covered the same rights in the Act, judges paying attention to the debates might read this as an admission that Congress knew it had no power to pass the Act without the help of the constitutional amendment. So they might accordingly strike down the Act. Congress did not want this to happen, David explains, so instead of discussing what they truly believed about the Act and the Privileges or Immunities Clause, they engaged in a pattern of strategic silences, omissions, and misdirections, to use David's terms. Now here, I have to commiserate with David. Like most of us writing about the 14th Amendment, David has to explain why the framers never claimed to understand the amendment in a manner that we insist they actually understood the amendment. It's a common problem. In this case, though, I don't think that this particular fear of judicial invalidation is why they didn't openly adopt David's theory. To begin with, Republicans had no fear whatsoever about linking the Civil Rights Act to the 14th Amendment. Soon after passing the amendment, both Democrats and Republicans hit the road campaigning for re-election that fall in the congressional elections. And the 14th Amendment became the central focus in the campaign speeches across the United States. And I haven't done an empirical investigation, but I'd bet about 70% of the Republican speeches expressly claimed that Section 1 of the 14th Amendment protected the same rights as those protected by the Civil Rights Act. And in fact, there was very good reason for the Republicans to publicly link the amendment to the Act. Democrats at that time were campaigning on the claim that the 14th Amendment in general, and the Citizenship Clause in particular, was going to be used to force black suffrage on the United States, both North and South. Most states in the North strongly opposed black suffrage and would continue to do so for years. So the Democrats' claim, if persuasive, would have killed the Republicans in the upcoming fall elections. And if the Democrats gained enough seats in those elections, the 14th Amendment was doomed, along with Republican congressional reconstruction. So in response to the claims that Section 1 opened the door to forced black suffrage, Republicans linked the amendment to the Civil Rights Act. In speech after speech, Republicans claimed Section 1 simply protected the same rights as the Civil Rights Act. And that act did not give anybody the right to vote. Everybody knew that the rights of citizenship did not include suffrage because women and children were citizens and they, after all, did not have the right to vote. So in other words, instead of fearing a public connection between the Act and the amendment, Republicans actually were quite anxious to make a connection between the Act and Section 1, regardless of how that connection might have been viewed by judges currently reviewing the Civil Rights Act. So if they had no problem linking the Act and the amendment, why didn't they clearly link the Civil Rights Act to the Privileges or Immunities Clause? Well, I think the answer most likely is because the Act wasn't linked to the Privileges or Immunities Clause. It was linked to the Due Process Clause. When the House debated the Civil Rights Act, for example, John Bingham refused to support that act, and he had two main objections. And by the way, I don't think he ever voted in support of it. He opposed it, and then he refused to vote. He abstained. First, Bingham claimed that the Civil Rights Act was an effort to enforce the Due Process Clause against the states. And Congress at that time, Bingham reminded his colleagues, had no power to enforce any of the Bill of Rights against the states. Doing so would require a constitutional amendment. Secondly, the amended version of the Civil Rights Act had limited its protections to only citizens. And this, to Bingham, was unjust, because equal rights of life, liberty, and property belonged to all persons. Bingham insisted that instead of passing this unjust and unconstitutional legislation, Congress should pass Bingham's proposed amendment, which protected the due process rights of all persons and empowered Congress to pass legislation like the Civil Rights Act. And that's true for both versions of Bingham's Section 1. And here are just a couple of excerpts from Bingham's speech in which he opposed the Civil Rights Act. Quote, "I proceed to present to the consideration of the House my objections to the bill. And first, I beg, gentlemen, to consider that I do not oppose any legislation which is authorized by the Constitution of my country to enforce in its letter and its spirit the Bill of Rights as embodied in that Constitution. I know that the enforcement of the Bill of Rights is the want of the Republic. The enforcement of the Bill of Rights, touching the life, liberty, and property of every citizen in the Republic within every organized state in the Union, is of the reserved powers of the states." And again, "I'm with the sponsor, Mr. Wilson, in an earnest desire to have the Bill of Rights in your Constitution enforced everywhere, but I ask that it be enforced in accordance with the Constitution of my country." He then addresses its unjust limitation to citizens. "In respect to life, liberty, and property, the people by their Constitution declared the equality of all men, and by express limitation forbade the government of the United States from making any discrimination. This bill, sir, with all respect, I submit, departs from that great law. The alien is not a citizen. You propose to enact this law, you say, in the interest of the freedmen, but do you propose to allow these discriminations to be made in the states against the alien and stranger? Can such legislation be sustained by reason or conscience? Is it not as unjust as the unjust state legislation you seek to remedy? Your Constitution says no person, not no citizen, shall be deprived of life, liberty, or property without due process of law." Bingham never supported the 1866 Civil Rights Act. Instead, he went forward with the 14th Amendment, an amendment declaring that all persons have due process rights and the rights of equal protection, and then the 5th section giving Congress power to enforce the same. Once ratified, Bingham joined Congress in repassing the Act and extending almost all of its provisions to all persons. And in fact, to this day, the Civil Rights Act retains its original title, an act to protect the civil rights of all persons. So in conclusion, I fully support David's efforts to investigate the rights of national citizenship. It needs more work, and I'm glad you're working on it. And he's certainly right that citizens share with all persons the rights of due process and equal protection. But these rights are not among the unique privileges or immunities of citizens of the United States, and they cannot serve as a guide to what Bingham accomplished when he produced the Privileges or Immunities Clause. Jacob Howard and John Bingham, of course, tell us we can find the privileges or immunities of citizens of the United States in the enumerated rights provisions of the Constitution, chiefly in the amendments 1 through 8. But that's a conversation for another day. For now, I simply thank you for letting me read these chapters, and I look forward to reading the entire book. Thank you. Thank you.
The relationship between the Civil Rights Act, Section 1, and the various clauses I think, is not that the Civil Rights Act is the Privileges or Immunities Clause. The evidence is overwhelming of people saying all of Section 1 is the Civil Rights Act. and not simply the Privileges or Immunities Clause, or conversely, the Equal Protection, Due Process Equal Protection Clause or clauses. And without getting into the weeds on this, one of the provisions of the civil right, one of the rights you have is equal right to security in person and property, which strikes me as very closely analogous to the Equal Protection Clause. And so in that respect, it is the Equal Protection Clause sort of correlates with the parts of the Civil Rights Act, some of the rights enumerated. The right to sue, be parties, give evidence, has both a security in person and property aspect that belongs to human beings, but also, as I tried to point out, the South indicates why they try to split the difference, because they say, we're going to let the freedman testify in any case in which he is interested, but not others, because those are matters of public interest and they don't belong to the public. So these things are deeply intertwined, and I speculate that, in fact, one of the reasons for intertwining them in this way was to try to obfuscate the difference between the freedom of the 13th Amendment and the freedom of the citizen, just to weave together privileges of right to acquire real as well as personal property, not just real property, but also personal, which once they disintegrate these two things, for the most part they can throw in the subsequent statute. They put the property acquisition and transfer in one place, but I think they probably have to split the right to make enforceable contracts from the right to have your valid contracts enforced. But it's complicated. I think the evidence is also, and I shall have to include some of this, but I know Chris Green has done a lot of work in this regard, of people specifically mentioning the privileges and immunities of citizens of the United States in the Civil Rights Act. I mean, specifically mentioning that part in relation. Interestingly enough, one speaker I really like is House Speaker Colfax in one of his campaign speeches. He enumerates the Privileges and Immunities Clause with respect to each one of the provisions of the Civil Rights Act, but omits the equal security in person and property. And it doesn't look deliberate. It doesn't look accidental. I think it's deliberate. That is going to be a section that refers to human beings have a right to be protected in their person and property. And being a citizen or not a citizen does not add or subtract from that. But the right to participate in the markets might be something that belongs to members of the community of right, even though Congress, through a statute, through its, I believe, its naturalization power, can introduce new members, and therefore, through the Civil Rights Act, insofar as it says you can't discriminate against resident aliens, Congress is exercising a different type of power, naturalization. But so I should make that clear. I should make clear that maybe even a section on trying to map the CRA, the Civil Rights Act, onto the Section 1. And as for Bingham and due process, I think I did quote from that very speech. I think he's absolutely right. The Civil Rights Act is dangerous because it suggests aliens don't even have the right to security in person and property or due process, and that's bad. But that I don't think he would have said all of the Civil Rights Act is the due process clause. In fact, I think that would be really a novel or outlandish thing to say relative to the history of due process of law.